You're listening to Cover Your Assets, a podcast that discusses the timely and significant legal issues faced by employers. Kathleen Jennings is an attorney who has over 30 years of experience in advising employers as to their legal responsibilities and has written extensively about employment law in her popular Cover Your Assets blog. If your business has employees, you cannot afford not to have your assets covered.
Hello, everyone, and welcome to Cover Your Assets, the labor and employment law podcast. I changed the title. I don't know if you remember this, but when it was we first came up with the title for Cover Your Assets, the podcast. It's named after our resident expert / my sister, Kathleen. I put the podcast up on all the different podcast formats, Apple and Spotify and all that. And I noticed, I'm like, wow, there's a ton of Cover Your Assets podcasts. They usually are about financial advice and things like that. And then I realized, I'm like, oh, well, maybe I should change it to the employment law podcast. But I realized that your blog that this is based off of is the labor and employment law podcast. Is that not correct?
That is correct, Tom. So I'm very glad that you have corrected the name of the podcast.
And it's much longer, so we have something more to say every time that we start the podcast. But this week, let's get to the topic. And it is an interesting one because it's one that I, as usual, have a story that goes along with it. But I think it's
I'm not surprised.
I think it's something that's very pertinent to a lot of people out there. And hopefully you can, you begin the podcast with maybe discussing the difference between, I know there's something called like a non-compete and a non-disclosure. Is that the two types of agreements? And what are our podcast topic? And we like to be a little bit smoother at the beginning, but that's okay because we're normal people. It is about agreements that you sign when you start a new job, and the non-compete, non-disclosure, non-solicit. That's the other one. That's the one that I was missing. So what are the three types? What are the industries that they typically affect? And I will let you take it away from here, sis.
Well, Tom, what we like to call these in a group are restrictive covenants. They are covenants that restrict someone in some way in their employment or future employment. And as you correctly identified, we have types of restrictive covenants include non-compete agreements, non-solicitation agreements, non-recruitment of employee agreements, and non-disclosure or confidentiality covenants. Generally, the non-compete covenants are the type of covenants that say you cannot perform this type of work for the same type of company within a certain radius of distance from where you used to work. The second type, the non-solicitation, is generally something that will prohibit an employee from soliciting the customers or clients of their employer for another entity. Like if they go to a new company, they can't then turn around and start soliciting the customers and clients that they did business with at their old employer. The non-recruitment has to do with you can't recruit the folks that you worked with at your last employer when you move to a new employer. And the non-disclosure or confidentiality prohibits an employee from disclosing confidential information. It's related to protecting trade secrets. But is there something that a company has that is considered confidential, and the disclosure of which to a competitor would provide some sort of advantage to that competitor? The employer wants to take certain measures to protect that kind of information and prevent employees from disclosing it so the competitors don't get their hands on it.
Okay, well, let's kind of dive into each one of these individually. I'll start with the non-recruitment. And I guess the question that I would pose is that if you worked for a company and then you I would assume this would pertain more to supervisors than, say, a regular employee. But So I take a job at another company, and I was a supervisor at company A. I go to company B, but then everybody at company A really loved me, and they want to come along and work for me, which could potentially decimate the workforce of company A. Does company A have a legal recourse in terms of the non-recruitment agreement? I mean, is there responsibility in terms of like to say, oh, you guys can't come work for me, or are they able to come work for me of their own volition?
What we like to distinguish between is active recruitment of those employees versus passive acceptance. And this will apply also to the non-solicitation of customers or clients. If you have a non-recruitment covenant in your employment agreement and it's enforceable, and everybody needs to know that all of these agreements are subject to state law for the most part. Every state has different laws that pertain to restrictive covenants. So it's very hard to come up with a one-size-fits-all agreement that will be enforceable in all 50 states. So you have to know your state. You have to know your state law when you draft these covenants. So if you have an enforceable non-recruitment covenant, you are not allowed to pick up the phone and call these folks that you used to work with and say, hey, come to work for me. However, if those folks pick up the phone and call you and say, hey, Thom, I hear you've gone to company B. I'd like to come over there too. Arguably, you're not soliciting them. They want to come over and work for you. So those types of agreements are hard to enforce because it's hard to distinguish between the active efforts. You may have a smoking gun like an email. If you send an email out to all of the folks you used to work with that says, hey, come work with me at company B, then you're going to be in a bit of trouble. But for the most part, I hope that you would be smarter than doing something like that.
So what's the recourse as far as, well, a couple of things. When an employer decides to draft an agreement, a non-recruitment agreement, what are the elements that they should include? And also, is there a benefit to an employer maybe looking for some kind of, settlement or something like that? I mean, is it something that's worth pursuing if indeed employee goes from company A to company B?
I think the non-recruitment covenants are probably among the hardest to enforce. What is more likely, or what you're more likely to see employers try to enforce, are the non-compete and the non-solicitation agreements. And if an employee or a former employee is actively acting in violation of those types of covenants, or the confidentiality covenant, that's also a very important covenant to a lot of companies. The first recourse of the company is often to go to court and seek an injunction against the employee, the former employee, and possibly also the company they're working with, to stop whatever actions they claim the employee is engaging in to violate that agreement.
So I guess to me, I think in terms of employers, one of the things that maybe they have to be acutely aware of is the potential of hiring an employee that has one of these agreements in place. So maybe that employee, I'm hiring somebody, I don't have a non-recruitment or non-solicit or any of those types of things. Does the potential employee have an obligation to tell you if one of those agreements is in place? And I guess kind of the secondary question to that is would you advise employers when they're looking for new employees to include that as part of the hiring process?
I think it's a good idea in any industry where these types of agreements are normal or routine for an employer to always ask an employee, either after they've been given an offer of employment or soon after hire, if they have, really actually before hire, if they are a party to any type of employment agreement or any restricted covenants, so that then the new employer can have their counsel look at that agreement and determine, is there a problem? Because if the new employer is aware of the agreement and goes ahead and the new employee violates the agreement and the old employer goes after that employee, in some cases, the new employer, and this does get kind of confusing, doesn't it? The new employer could be liable as well. So it is important for the new employer to be aware of these types of agreements and to have their own counsel review them to see whether these are enforceable covenants or what they can do about them.
So I guess the question is, which industries are the ones that usually have, where it's standard practice to have this restrictive covenants?
Well, tech, IT, those kinds of things, anything with scientific secrets, medical field, there's a lot of these doctors, hospitals have a lot of these types of agreements. Financial services have these agreements routinely. They can be anywhere. The issue is whether the employer has a protectable interest that they want to protect an employee from using to the employer's disadvantage if that employee leaves the company, or even during the time that the employee is with the company.
So I'm curious, so at what point does, if an employer, have to notify an employee that one of these agreements is a condition of employment? And I say this because let's say there's a situation where, okay, so I'm at company A, I'm ready to go to company B. I apply to company B hires me. We go through the whole process. I give notice to company A. I get there. It's my first day of orientation, and then they slap this agreement in front of me. And I go, whoa, wait a minute. I didn't know that such an agreement existed. And now I either have to sign the agreement, or I've already quit the job at company A, and company B is throwing this in front of me. Would the employee, if the employer did not put their ducks in a row, would they have a case to say that they signed these agreements under duress, and maybe they would be unenforceable because of that situation?
That is usually not a winning argument, although obviously the employer has all of the power at this point. It really depends on the employee and what type of job they're taking. Higher level executives or higher level people with greater knowledge will have better bargaining leverage. But for the most part, the average employee will have no say. They'll either have to sign this agreement or not start the job. And that's a choice they have to make.
But I would assume that you would advise an employer to be as transparent about these types of agreements up front. It would make, don't you think it would be ethically better for them to let people know during the hiring process or during the recruitment process, the interview process, before they do a job offer, that these types of agreements are going to exist?
I don't know that normally comes up unless the applicant asks about it. Hopefully, if the applicant has done their homework on the company, they may find out that there are others at the company that have these types of agreements. But usually the agreements are given to a new employee at the time of hire or orientation. So yeah, if you've already quit your job at company A and then you have one of these agreements with company B, why wouldn't you sign it at that point? Hopefully you're not planning on competing against this new company that you just joined, or are you?
Well, it really is kind of a gray area, because if you think about it, especially if I work in a particular industry, so in your case, you're an attorney, and you have a certain clientele, and you have a practice that is somewhat specialized, correct? So if you were to go to another law firm, I would assume that you'd be doing the same type of work, at least in most cases. So if there was something like a non-compete agreement, that could put you in a very difficult situation, couldn't it, in terms of trying to find another job? And I believe that on some level that could have an impact on whether these agreements are enforceable. Like if these agreements make it so that you cannot continue to work in the field that you are established in, then it doesn't matter anyway.
Well, these agreements are considered for the most part to be in restraint of trade. So yes, they do restrict the ability of people to go to work for different employers in the same industry. And so you're absolutely correct. The ability of an employee to find other work or to have gainful employment is weighed against the protectable interest of the employer. And then again, there's different states have different ways of analyzing these covenants. You have to know the law of the state that you're in so that you can understand whether a covenant is going to be enforceable or not.
Yeah, because I mean, at its core, I mean, if you're going to look for an employee, I mean, ideally, you're going to hire somebody that has experience in the industry. And if you're going to hire somebody in the same industry, I mean, chances are that they're going to be with a competitor or at least with somebody who's doing the same type of work that you're doing. So, I mean, I guess I understand why an employer, for instance, in the non-solicit. So I hire somebody to build my business up and they go to somebody else that does the same type of work that we do. I mean, the reality is that I paid for them while they were building their own sales portfolio and all that kind of stuff. And so I have a vested interest. I'm the one that came up with the company, and they shouldn't just be able to capitalize on that and just take that whole book of business and bring it somewhere else. But again, it seems to me like the problem's going to be, how do you determine whether if somebody says, oh, the reason I do business with you is because of you as the individual or because of you as the company. So I think a lot of this can get very muddy. And I wonder if there's anything that you can do to kind of be proactive in terms of shaping these agreements where you don't run into those things where it really just becomes a back and forth between the ex-employee and the employer.
Well, in addition to shaping the agreements, and I can't emphasize enough, know your state law, know what's enforceable under your state law. A lot of what you look at is the actions after the employee leaves the old company. We were involved in some litigation where we were representing a small startup company, and they were being sued by a large company in the same business because the small startup company, one of the officers of the large company went to the small startup company, but didn't take any customers with him. However, the small startup company was doing so well that the large company thought, well, he must have taken customers with him because otherwise, how would they do so well? So large company went out and got one of the largest law firms in the world. Kid you not, they had like 3 attorneys at every deposition. They spent millions of dollars on this case and sued the smaller company. And there was absolutely no evidence that this guy took any customers with him. The reason the smaller company was doing better was because they offered better service. And that's why customers went to them. There was word of mouth, and they were getting customers in a different sector of the business as well. But it cost them a lot of money too, just to have to fight this case. So sometimes the litigation is going to happen just because maybe a company is unhappy that a competitor is doing so well in the same industry.
Yeah, I guess it said that really pertains to, it seems like a lot of specific industries. I know you mentioned like the healthcare industry. I mean, how would that come up in terms of, what would that, a doctor going to another hospital?
Doctors, when they leave a practice, most doctors have agreements that limit their ability to practice within a certain mile radius from where they're currently practicing, because the practice they're with or the hospital system they're with doesn't want them to take the patients with them. But again, you come down to, actively soliciting versus passively accepting. Passively accepting customers is legal and not in violation of these covenants. So a lot of the litigation will center on, what efforts did the ex-employee make to reach out to people versus how did the customers or clients reach out to this person after they left.
So, in reality, and if you're going to leave a hospital or whatever and you're a doctor, you're probably better off just to go to an area that's far enough away that you're not going to have to deal with this kind of thing, right?
Yeah, usually the mileage is not that great. It's not like you have to necessarily move to another state or anything like that. They just don't want you close enough by that it's easy for the patients to just, drive down the street.
And I guess we'll finish up with the non-disclosure agreements. And my personal opinion is that I think that's kind of a no-brainer. So if you're working for a company and there's certain things that they're doing that need to be protected, and this may not be a great example, but I think of like Kentucky Fried Chicken. Kentucky Fried Chicken's recipe is an important recipe, and they'd obviously, if somebody knew that specific recipe, you wouldn't want somebody going to open another chicken place and using that specific recipe. And of course, with technology, obviously that's really important. And I know you and I, we grew up in Rochester, New York. There was a huge case with Polaroid and Kodak, and Polaroid developed instant photography technology. Kodak came up with an instant camera that violated some of those patents and whatnot. And I assume maybe, I don't know if that necessarily falls under the same category as far as non-disclosure, but I think that some Polaroid people had come to Kodak, and that's how they learned about that kind of stuff. So I think a non-disclosure agreement, it seems to me that of all of the restrictive covenants, this may be the most, the easiest to kind of enforce. Is that correct or not?
Well, it should be. Again, as long as you are focused on protectable interests, as long as the information that you're protecting isn't something that's already readily available. And you should have your definitions in your agreement that say that it's not readily available in the public's eye. And along with the confidentiality covenant, however, the company also needs to make active efforts to keep the information confidential. That means password protect things, or, back in the old days, the old locked filing cabinet, but don't make it so accessible that you can't claim that it's actually subject to some type of protection. What we see in these cases, litigation-wise, you'll see, and these are the fun ones, because the ex-employees will normally start emailing things or downloading things a few days before they leave the company. And I guess they don't realize that all of that's going to be visible on their work computers, because they always do it on a work computer. And so when a company has someone go into the work computer and see this data dump, they know something's up. And even if the employee hasn't taken something that's arguably protectable, it just looks bad. And it's likely to cause some type of nastygram followed by some litigation.
All right. And as usual, we will close with a tale from Thom. The tales of woe, I guess we could probably start calling them.
Thom, you have a restrictive covenant tale?
I know, it's hard to believe.
It is hard to believe. In your storied employment history. Do tell us, Thom.
This one, I don't know, this one will probably be fairly quick. I was working for a digital services agency. And digital services agency, basically websites, web development, web marketing, all things related to the internet. And I went to look for another job because we were having some issues with. I was having some issues with my employer, and we actually had, as a group, I think right before I had left, our CEO had given us this agreement that we had to sign, and we all kind of looked over it and we said, is this a non-compete agreement? He said, oh no, this isn't a non-compete.
I believe you sent it to me, didn't you, Thom?
I didn't want to say I sent it to you. I didn't, without asking you if I could say that I sent it to you, but I did. Yes, I sent it to you. So I happen to have a sister who is a resident expert.
And what did I say?
And you said, you can sign it. This thing doesn't look like it's very enforceable. And there was definitely some things in it. So we signed it. In fact, my son, your nephew, worked there with me as well. We both signed it. And he left and he went to do something entirely different. He went to be an executive recruiter. But then I went to
doing very well, I might add.
He is doing well. Not that he would ever listen to this podcast, but if he does,
I know. If he does, we'll give him a shout out.
And the best thing he's done is make that granddaughter of mine, Michelle, Elizabeth Jennings. She likes to say all three of those names. Just turned 4. But anyhow, so signed this agreement. I went to get another job and with a smaller agency, and they were, of course, they wanted to hire me because I had experience in the field, and they asked me about the agreement. I gave them a copy of it, blah blah blah. So I wound up. I had a call list, and if you're in sales, you'll get a list of potential clients that have either done, I don't know, maybe sent an email or an inquiry or something like that, and you'll call and you'll follow up. So I had sent off an email to somebody that wasn't my personal client when I'd worked for this other company, but they did business with my previous company, and honestly, I didn't even know that at the time. And so my boss calls me and he says, "Oh, it looks like you've solicited somebody that used to do business with your old employer." And I'm like, "Well, I didn't even know that they did it." And he said, "Well, we got a letter from them, from their attorneys, that said that you violated an agreement, that you're soliciting business for them." And I said, "Well, first off, I wasn't even soliciting them for services that my previous employer even offered. This was an entirely different thing. And secondarily, again, I mean, this wasn't even somebody that I had worked with, so there's no reason that I would even know that they did business with our company." And the employer, he was a small shop, and he just said, "Well, we can't afford the potential litigation." And so he let me go.
Wow.
Yeah.
That's cold.
It was cold. But
yeah.
But in retrospect, I guess I don't know. I mean, the lesson there is, I didn't think the agreement was crafted really well. I probably could have contested it on some level. I mean, I may have even been able to get some legal recourse against my former employer for putting me in a position where I wasn't able to work in that industry. But
interference with employment.
Yeah.
Yeah.
But
and in New York, those types of agreements are very difficult to enforce.
Yeah. But at the end of the day, I didn't think it was worth the time. But I don't know. I mean, what's your thoughts in terms of employer A and employer B and how they could have potentially handled the situation better? Because I think obviously there's some ethical issues that are raised there. Company A is I know they're not doing well. I mean, they lost a lot of employees, and I think that obviously when they do things like that are heavy-handed, it certainly can have a ripple effect in terms of morale and their ability to recruit new employees. I don't know that Company B. I think Company B is pretty much where they were when I was with them 5 years ago, so they haven't really expanded either. So, what's your thoughts, resident expert?
Well, my thoughts would be that if you are soliciting a client of the former company that you never had material contact with while you were with former company, and soliciting them for services that former company didn't even offer, then it wouldn't have been enforceable, or they wouldn't have been able to enforce that agreement against you. You weren't acting in violation against it or in violation of it. However, a new company, I can see apparently are just litigation averse and or just incredibly cheap and didn't want to fight it. And there's some companies that will, and there's some companies that just don't want to spend the money. And so, yeah, company A was very heavy-handed and got their way that time, even though they shouldn't have.
Yeah, and interesting enough that aforementioned son of mine, Thom Jr., he went to work for a company in the same sector. This was before we both worked for company A, and they tried to do the same thing. They sent a nastygram, as we like to call it, a letter from an attorney, and the other company was big enough to say, "Nah, you're not gonna intimidate us. We'll fight to keep the employee." So, I guess maybe if you were to give advice to employers, since this is a podcast designed for employers, that you kind of have to choose your battles, and obviously these agreements should exist in some industries, but they have to be crafted well. And I just hit the microphone. Did you hear that?
I did.
Oh, goodness. Everyone will stop listening. But anyhow, these agreements should be crafted well. You also have to think about the ethical implications and, again, the potential of having to deal with potential litigation. Correct?
Absolutely. Yes.
Yeah.
And know your state law. Look at your state law. If you have businesses that do business in multiple states, that's going to create an even bigger issue. Or if you have employees jumping from state to state, you'll also have choice of law issues in these types of agreements. So it's the kind of thing where you really do need to consult with an attorney to draft the agreement. Don't just pull it off the internet and think that that's going to work. And then also have your attorney on hand if you hire an employee that has one of these agreements, or you get a nastygram about one of these agreements. Don't try to handle it yourself. You definitely need to have counsel involved in these types of problems.
And ultimately, the best way to avoid these types of conflicts is take care when you're hiring and treat the people that are working for you well, so that they don't decide to go to other companies.
Well, that would be one way to definitely cover your assets, Tom.
Absolutely. Well, with that fantastic tag on our name, Cover Your Assets, I will say you thanks again, resident expert and sister Kathleen. And
always a pleasure. Favorite brother, Tom.
And as always, please consider writing us a review, sharing the podcast with your friends in the in the industry, people that HR people, business owners, anyone that would really get something beneficial from this particular podcast. And of course, thank you everyone out there for listening. We will see you next week on Cover Your Assets, the Labor and Employment Law Podcast.